For the Thom Hartmann University Book Club today, we're reading from Speeches and Addresses by Delfin Delmas. Delfin Delmas was the lawyer who single-handedly and for free, pro bono, saved the redwoods in California. And then he went and on behalf of Santa Clara County, he argued the Santa Clara County versus Southern Pacific Railroad case before the Supreme Court. And this is a book that he published in 1909. This is the actual original first edition. You can find reprints on the internet. In 1909, he published a collection of his speeches, including his presentation to the Supreme Court on corporate personhood, which I am reading to you. The shield behind which it attacks the Constitution and laws of California is the 14th Amendment. It argues that the amendment guarantees to every person within the jurisdiction of the state the equal protection of the laws, that a corporation is a person, that therefore it must receive the same protection as that accorded to all other persons in like circumstances. The special argument advanced is that if an individual owns property and a corporation owns precisely the same kind of property, the law protects them both equally in the use and enjoyment of the property. And for the protection it affords the government can demand no greater or different return, the shape of taxes, than it demands from the individual. That argument I beg leave to controvert. He says, in my mind, the fallacy, if I may be permitted to so term it, of the argument lies in the assumption that corporations are entitled to be governed by the laws that are applicable to natural persons. That, as it is said, results from the fact that corporations are persons, and that the last clause of the 14th Amendment refers to all persons without distinction. The defendant has been at pains to show that corporations are persons, and that being such, they are entitled to the protection of the 14th Amendment. There was scarcely need of the array of learning and elaborate disquisition which has been displayed on this point. Blackstone says persons are divided by the law into natural persons or artificial persons. Natural persons as such are such as the God of nature formed us. Artificial are such as were created and derived by artificial laws for the purposes of society and government, which are called corporations or bodies politic. This definition suggests at once that it would seem unnecessary to dwell on that though a corporation is a person, it is not the same kind of person as a human being, and need not of necessity enjoy all the rights. When the law says any person being of sound mind and of age of discretion may make a will, or any person having arrived at the age of majority may marry, I presume the most ardent advocate of equality of protection would hardly contend that corporations must enjoy the right of testamentary disposition or of contracting matrimony. Keep in mind, this was 1886. The equality between persons spoken of in the 14th Amendment obviously means equality between persons of the same nature or class, and not equality between persons whose very natures are absolutely dissimilar. Equality between human beings, if the rights of natural persons are involved. Equality between corporations of the same class, if the rights of artificial persons are involved. The whole history of the 14th Amendment demonstrates beyond dispute that its whole scope was and object was to establish equality between men, an attainable result, and not to establish equality between natural and artificial beings, an impossible result. He goes on to say, could Congress have by any possibility meant to confer upon artificial persons the same rights and the same respects as were enjoyed by white citizens? Could it be, for instance, have meant that a corporation should have the same right to give evidence as white citizens? And as to contracts, may not the state which creates corporations impose certain limitations upon the power or right to make contracts? Because the right of a white citizen to make a contract extends to all things not forbidden by law. Must the law of a corporation be coextensive with it? Under this leveling statute, was it intended to abolish the right of the state to impose terms and limits upon its own creatures? Again, keep in mind this is 1886. Again, as to the burdens, the statute says that the taxes, license, extractions of every kind and none other, which may be demanded from white citizens, shall be demanded from all persons within the state or territory. Here, the burden to which a white citizen is subjected is the standard of measurement. To justify a tax, license, or exaction, it must first be shown that it is demanded from white citizens. If it is not, it cannot be demanded from any other person within the state. Was this meant to apply to corporations? Was it intended that corporations should be subjected to no tax, license, or exaction that was not imposed upon white citizens, any law or statute to the contrary notwithstanding? It is certain that this law has never been so understood or interpreted by any state In other words, no state has ever said a corporation is a person. And if it is now to be so interpreted, what, I ask, is to become of the vast mass of legislation in all the states by which taxes, licenses, and exactions are demanded from corporations where none whatsoever is demanded from white citizens? To take a single illustration, by the statute of Massachusetts, every savings bank incorporated under the laws of the Commonwealth pays a tax of 1.5% on its deposits. No such tax is imposed upon any individual or citizen. This court has held that this was a tax on the corporation, the person. That the 14th Amendment was intended to secure equality between persons, which in the nature of things were equal, and not between one class of persons and another class entirely dissimilar, seems so plain that the defendant itself is at times compelled to admit it. As good a definition as I could desire of the meaning of the words equal protection under the law, I find in the arguments formerly delivered here in the San Mateo case by the learned gentleman the opposite. The Delfin Delmas is the author, Speeches and Addresses.